and teach each other through interactions in social and intellectual contexts. A vibrant dialogue is not possible if students wall themselves off from opposing points of view. And having served as an advisor to several student groups here in the time that I've been on the faculty at Moritz, I think that this is absolutely accurate. Much of the teaching and learning that occurs in a law school occurs outside the classroom, including in the context of student organizations. And thus, the university, Hastings in this case, by having a policy of non-discrimination with respect to school-subsidized and supported organizations, was serving this pedagogical interest that, in my opinion, Justice Kennedy quite nicely describes. I want to say a few words on Justice Alito's dissent in closing and come back to Ohio State's current policy. You know, on rereading this case this morning, one of the things that struck me is that the legal disagreement between the majority and the dissent in this case is actually very narrow, in my opinion. I'm kind of curious as to whether David agrees or disagrees with me on that. But on reading the opinions, it strikes me that they don't really disagree much on the law. They agree in particular that the university has created a limited public forum, and therefore that the university can't discriminate based on viewpoint in this public forum. So the question before the court is really a narrow one, not so much what the law is, but the application of the law to these facts, where the majority and the dissent really most starkly differ is not on what they think the law is, but on what they think the facts are in this case. And the thrust of at least much of Justice Alito's dissent is on his conclusion that CLS's policy, while perhaps couched in neutral terms, was really viewpoint discriminatory, that it had, as we say in constitutional law generally, a discriminatory purpose insofar as it was intended to discriminate against religious groups. Now, here's where I agree with Justice Alito. If, in fact, this policy were intended to discriminate against religious groups as compared with non-religious groups, then I do think that the policy would be at least presumptively unconstitutional. Where I disagree is I don't think that that was proven in this case. Now, there was one point in Justice Alito's dissent that I want to quote to you because I found this especially persuasive, and I think that if he's right, if Justice Alito is right, it raises some serious questions about the constitutionality of the Ohio State University's current policy when it comes to student groups. Here's what Justice Alito has to say. He argues that Hastings is, in effect, according differential treatment to non-religious groups as compared to religious groups. His example is the Hastings Democratic and Republican Party groups. What he says is that these student groups, these political groups, were allowed to exclude members who disagreed with their party's platforms, whereas religious groups are subject to a different standard. They, unlike political groups, are not allowed to discriminate on the basis of belief or sexual orientation. Now, if this were really the case, I would agree with Justice Alito, right? If the university were discriminating against religious groups in favor of non-religious groups, effectively applying a more lenient policy to non-religious groups, I would agree with him that this was viewpoint discrimination that violates the First Amendment. And this brings me to my final point. If Justice Alito is right, then I think, and on this point I think he is, as a legal matter, not a factual matter, then I think that our current policy at The Ohio State University is unconstitutional. Let me explain to you why. We have a policy that facially discriminates in favor of religious groups as opposed to non-religious groups. In other words, it is the mirror image of what Justice Alito thought Hastings' policy was in the CLS versus Martinez case. Let me quote to you from Ohio State's policy. All student organizations to be recognized and eligible for funding are required to include a statement of non-discrimination on various bases, including gender, race, sexual orientation, and religion. But there's an exception for certain groups. Specifically, the policy says a student organization formed to foster or affirm the sincerely held religious beliefs of its members may adopt a non-discrimination statement that is consistent with those beliefs. Note that the only groups that are eligible for that exemption are religious groups. So non-religious groups that claim that they must discriminate in order to further their objectives are subject to a different, less lenient policy. This, as I said, is the mirror image of what Justice Alito thought Hastings' policy to be. The difference is that rather than discriminating against religious groups in favor of non-religious ones, Ohio State's policy discriminates in favor of religious groups and against non-religious ones. So to take a couple of examples, let's say that a women's group formed and maintained that in order to promote their sincerely held political beliefs, it was necessary to exclude men. Or a gay and lesbian group formed and claimed that in order to promote their political beliefs, it was necessary to exclude heterosexuals. Or to take a less sympathetic example, but a group that I think would also have a strong claim against the constitutionality of our current policy, suppose an all-white students association were to form and claim that in order to promote their beliefs, they had to exclude racial minorities. Under our policy, these groups don't get the exemption that religious groups get. Our policy, therefore, discriminates in favor of religious groups against non-religious groups. And if we accept Justice Alito's premise, as I do, his legal premise, then our policy violates the First Amendment's prohibition on viewpoint discrimination. So the bottom line for me is equality in the realm of speech. Not speech versus equality, but equality in the realm of speech. And I believe that the opinion in CLS versus Martinez furthers this ideal. Thank you.
Hi. Feels good to be back. I have been in and out, but I miss you. I have, organized my comments in a way that I think will be helpful for you to understand, but in light of the forceful point that Dan makes at the end of his comments, I think that for me to kind of postpone addressing that until the end of my comments might be, something might get lost. Let me just quickly, and then I'll go back to, what I wanted to talk about. Just address Dan's suggestion that, Professor Tokaji, I'm Dan, I'm David, he's Dan. Okay. Okay. That perhaps the OSU policy, which provides for accommodation for religious groups, is unconstitutional. In arguing that based on the fact that the claim is all speech is the same and has to be treated the same, I think I respectfully disagree with him. I think that we have under the Establishment Clause and the Free Exercise Clause developed, the Supreme Court has developed the opportunity for the government to accommodate religious exercise when it imposes burdens on religious exercise in the course of its regulation. And here, the state or the government has said that you can form groups, however, we're going to impose a condition. This is the university speaking. However, we're going to impose a condition that you must not discriminate in any way based on religion and so forth. That burdens the freedom of association and the religious exercise of religious groups that get together for purposes of worship and exploration of religious views and seek people of the same faith to do so, understandably. I think the state is perfectly free to accommodate those groups and not provide the same accommodation for the Democratic Party and the Republican Party. In fact, that was the core of the case that I argued in the Supreme Court several years ago. The state argued that the accommodation of religion, religious exercise of inmates without accommodating their other First Amendment rights violated the Establishment Clause, and the Supreme Court said, no way, it's a legitimate accommodation. So, but that is a technical argument on the law. Now let me back up to the beginning. At least you have another view of Dan Tokaji's critique. Let me first tell you a little bit about myself and make sure that I could talk about myself forever, but my history, some of which was provided in the introduction, I'm deeply committed liberal. My roots are in the ACLU. I was on the ACLU staff. I'm still an ACLU supporter. I'm Jewish. I'm a good Jewish liberal. I've been advisor of the Federalist Society, and I've been advisor to the Christian Legal Society, both, because I felt that they needed someone to speak on their behalf, on the faculty, when I felt that they were not, when I felt they were under fire and they needed someone to stand with them, and thus I did. I probably am the first and maybe the only Jewish advisor to the Christian Legal Society. Now, let's talk about the case. I think that I'm profoundly disappointed, and it took me a while to get over my outrage, frankly, and calm down enough to be able to talk about it in the measured and thoughtful way that Professor Tokaji has just talked about. It's disappointing, and let me explain. I think it's going to institutionalize dishonesty among student groups. Check the box in order to get your recognition. I know it's happening at religious student groups. I know it's happening already. I've had a faculty advisor tell me so, and I would guess, so I'm aware of at least one group, and I'll bet there are others on campus that that absolutely want to have what people of the same faith together in the same organization, and do not feel that it's appropriate for people of different faiths to join them to the extent that they don't share their values and their religious beliefs. Now, the purpose, of course, of the regulations, we start with the fact that every university in the United States has student groups that span a broad spectrum of